So Apoorva has a question. Is this update true that the U.S. courts now have more adjudication power for cases where a USCIS DOS is tried in court?
To a degree, and we're not quite sure how this is all going to be played out. So essentially what happened is the U.S. Supreme Court recently overturned a major administrative law decision called Chevron, and that decision had shaped basically all of administrative law adjudications. It's the most famous case that upcoming lawyers learn in law school. And it basically said that the agency's interpretation should be given deference where there is any issue of ambiguity in the law. And so courts were then hesitant to question agency decisions unless those agency decisions were clearly unreasonable. Since it was a Supreme Court precedent, it applied to all of the lower courts. Now that that's taken away, I do think there is a lot more room to claim that USCIS's processes, decisions, any action that they take is unreasonable and out of line with the intent of Congress who passed the various immigration laws. So yes, there are openings now for us to take USCIS to court. That doesn't mean it's ultimately going to be successful. We'll have to see how it plays out. Like in issues like the NIW that I mentioned before, the discretion is actually written into the law. So Congress did intend to give USCIS a wide amount of discretion in a lot of cases, but they still can't make decisions that are arbitrary and capricious. That's a separate administrative law principle, and that's something that can still be questioned. As far as the Department of State, they are special. They have a whole separate set of precedents. Mandamus will continue to be a really good way to challenge Department of State inaction, I suppose. But as far as challenging Department of State decisions, I'm not sure that things have really opened up that much. We will see how much can be done. And I know there are a lot of attorneys who challenge Department of State regularly and who really want to see a lot of these doctrines, like the doctrine of consular non-reviewability, questioned, but I think there's less of an angle there. Chevron didn't really touch DOS that much. It's more USCIS.